Court Deputy Smith.
Please stand, sir. Agree. This Honorable Business 7 of the 30th Judicial District of Statute, Shelby County is off for the transaction of business pursuant to adjournment. All persons having business in this court is routed there. If attention and shall be heard. The Honorable Judge Lee Copper presiding. God save the state of Tennessee. The United States Honorable Court. Proceed, please.
Thank you, Deputy Smith. Good morning, everyone. Yes, sir. All spectators that might be in the hallway, tell them they can now enter the courtroom, please. Let's turn into the courtroom for me, please, also. Mr. Turner, good morning. For the record, State of Tennessee versus Billy Turner. Docket number 1705881. Mr. Turner is present. Mr. John Keith Perry is present. And Mr. Andre Thomas for Mr. Turner. Mr. Paul Hager, Mr. Austin Schofield present for the state. Council approach, Mr. Perry. Yes, sir. Ms. Thomas indicated that we need to have a sidebar before we start. Okay. Smith.
Drew, I've been forward, y'all.
Yes, sir.
Good morning. Myself, please, sir. Good morning. Good morning.
Thank you, ladies and gentlemen. We can be seated. Ladies and gentlemen of the jury, good morning. Good morning. How do you feel this morning? Good. How are your accommodations? Good. Do you have in a hotel that's serviceable at least? Yes. Are you comfortable? Okay. Yes. Are you getting fed well? Yes. Have you gained those 7 pounds that I told you about yet? Okay. And are the deputies treating you well? Yes. Thank you. Thank you again for your patience. When we stopped yesterday, the state had indicated had one of the witnesses called. This witness works in an undercover capacity still with the Memphis Police Department, so he'll state his name, we'll spell his name for the record, and the court reporter and the news media have been informed that they cannot film him from his chest up because of the security issue, because of the kind of work that he does. And once he's referred to by name and spells his name, nobody else will use his name in court because we want to make sure that he stays safe in what he does in his undercover capacity. State of Tennessee, you may call your next witness. Ms. Schofield, you may proceed.
Thank you, Your Honor. Detective, where do you work?
Multi-agency gang unit, Memphis Police Department.
And were you working in that capacity back in 2017?
Yes.
And were you working for a then Sergeant Beasley?
Yes.
Back then, was your unit engaged or part of Operation Rebound?
Yes.
And as a part of that operation, back on November 12th, 2017, what were you doing?
I was conducting surveillance on the case.
And who were you surveilling?
Sheriff Wright and Billy Turner.
Now, was this part of a larger operation where your team was trying to see what they were doing?
Yes.
Had Sheriff Wright come into town unexpectedly?
Yes.
And was your team aware of this due to a wiretap on both her phone and on Billy Turner's phone?
Yes.
And so at some point, did your team become aware that they may be trying to meet up?
Yes.
And, well, what did you do in response to that?
We met. We were directed to go to a specific location, and we met them there.
Okay. Do you remember what that location was?
483 Starlight.
Okay. Is that here in Shelby County, Tennessee?
Yes.
And did you, in fact, go to that location?
Yes.
And you talk about surveillance team. What does that entail?
We're told to follow a specific person, and we just pretty much tell them around, keep an eye on them, see what they're doing.
Now, are you in a police car and wearing a police uniform when you're doing this?
No, we're in unmarked vehicles.
Unmarked vehicles? Are you wearing plain clothes?
Yes.
Trying to be unobtrusive?
Yes, sir.
Okay. And so did you, in fact, go over to this Starlight address to see what was going on?
Yes.
And tell us what happened once you got there. What did you see?
Saw a white Jetta pull on the street and park in front of 482 Starlight. And I saw Michelle Wright get out the vehicle and go to 483 Starlight.
And were you expecting her to arrive at that location?
Yes.
Did you see any? Did she went inside? You said.
Yes.
Okay. Did anybody else arrive?
Yes, Billy Turner. He arrived in a maroon Chevy Silverado pickup truck.
Okay. Do you see him here in the courtroom today?
I do.
You point him out for me, please. Describe what he's wearing.
Red tie, gray suit, black suit.
We'll let the record reflect he's identified the defendant, Your Honor.
Record will reflect that the witness as pointed to has described and has identified the defendant, Mr. Billy Turner. You may proceed, Mr. Schofield.
And once he arrived on the scene, what did you see?
I saw him get out of his vehicle and go into a 483 Starlight, the same location where Ms. Wright was.
All right. And did they stay in there long?
Not really.
Okay. Did they come out
Yes, they came out.
together?
Yes.
And what did you see then?
I observed them walking up and down the street, talking,
Was anybody else with them?
and I was just them two.
And how long were they doing that?
About 30 to 35 minutes.
30 to 35 minutes walking up and down the street talking?
Yes.
Did you hear what they were saying?
No, I could not.
All right. Did this raise your suspicion?
Yes.
Was this, in fact, the type of thing the whole wiretap operation was trying to induce?
Yes.
While you were out there, were you in your car or were you outside of your car?
I was in my vehicle.
Okay. Did you take any pictures?
Yes, I did.
All right. I'm going to pass forward some items and just ask you to look through them and describe them one by one. For the judge, Your Honor, I've already shown these to defense counsel. I don't believe there's any objections.
Yes, sir.
And Detective, if you could, with the first one, just describe to the court what that's a picture of.
Sherry Wright walking to her Jetta, Jetta that she arrived in.
And the next one?
Billy Turner exiting his Chevy Silverado.
All right. And the next one?
Billy and Cheryl walking down the street talking.
Okay. And the next one?
Still talking, walking down the street.
And the next one?
Still talking, walking in the opposite direction, walking down the street.
And the next one?
This is them leaving the house in the middle of the street talking.
All right. And the next one?
Still in the middle of the street talking after they left the residence.
All right. And the next one?
Mr. Turner he walked Cheryl to her vehicle.
All right.
And he's standing in the doorway while she's sitting in the vehicle, driver's seat.
All right. Is that the last picture?
Yes.
Your Honor, we have those moved in as state next number exhibits.
And for the record, Mr. Perry, Mr. Thomas, any objections?
No objection.
Exhibit number 96. Photograph described by this detective as a photograph of Cheryl Wright. Leaving her Jetta. Exhibit number 96. Exhibit number 97. Photograph described by this witness as Billy Turner exiting a Chevy Silverado, exhibit number 97. Exhibit number 98. Photograph described by this witness as a photograph of Billy Turner and Cheryl Wright walking and talking, exhibit 98. Exhibit number 99. Photographs described by this witness as a picture of Cheryl Wright and Billy Turner still walking and talking. 99. Exhibit 100. photograph described by this witness as photographs showing Cheryl Wright and Billy Turner walking and talking in the opposite direction. Exhibit number 100. Exhibit number 101. Photograph described by this witness as photographs showing Billy Turner and Cheryl Wright in the middle of the street talking. Exhibit 101. Exhibit number 102 is a photograph described by this witness as a photograph showing Cheryl Wright and Billy Turner after they had left the residence. Exhibit 102. Lastly, exhibit number 103. A photograph described by this witness as a photograph of Billy Turner walking Cheryl Wright to her car. Exhibit 103. Schofield, you may proceed.
Thank you, Your Honor. May I publish these exhibits to the jury?
Yes, sir.
I was expecting applause, but okay. Who is this individual right here, Detective?
Lady Cheryl Wright.
And right here, who is this individual?
That is Billy Turner.
And what is this picture of?
Billy Turner and Cheryl Wright walking down the street.
All right. And this one?
That's Billy walking Cheryl to her Jetta.
And this one?
That's also Billy walking her to the Jetta that she arrived in.
And this one?
That's Billy Turner standing in the doorway of the vehicle, and Cheryl sitting in the driver's seat.
And these are a little bit out of order, but more pictures of them walking down the street.
Yes.
More pictures of them walking down the street.
Yes.
Now, Detective, you earlier said that you thought this was between 30 and 35 minutes they were out there walking up and down the street talking. At the report about this at 34 minutes, was that correct?
Yes.
Pass switch, sure.
Ms. Thomas and or Mr. John Keith Perry. Ms. Thomas, you may proceed.
Detective, this was November. What day was this again?
November the 12th, 2017.
Detective, through your investigation on that day, were you able to determine if there were other people at this home at 483 Starlight?
Yes, I was.
Were you able to determine what was going on at that home?
No, I was not.
If I was to tell you that it was a cookout going on there, would you be able to confirm or deny that?
Possibly, I couldn't confirm more than that.
So there were other people at the home.
Yes, it was.
This talk between Cher and Billy wasn't a secret, was it?
Well, it was kind of odd because they left a residence to walk down the street and talk privately.
They were walking down the street in public for anybody to see.
Yes.
No, of course.
Thank you, Ms. Thomas. Mr. Schofield.
They were walking down the street for anybody to see, but they weren't in the house for anybody to hear.
Yeah.
Right?
True.
That's it, Your Honor.
Mr. Thomas, any additional questions?
When you didn't hear that conversation, either, did you?
No, I did not.
Schofield, any additional questions?
No, Your Honor.
Detective, I want to thank you for being present in court today. I'm going to excuse you for any additional testimony on this case. You cannot discuss your testimony with anyone or allow anyone to talk to you about their testimony. And make sure you stay safe, sir.
Yes, sir.
You
Thank
step
you.
down. Have a good evening, sir. Have a good weekend.
You too.
Thank you, sir. Mr. Hager and Ms. Schofield, the state of Tennessee have an additional proof.
As we indicated yesterday, that's our last witness, and we'll rest our case in chief.
Thank you, Ms. Hager and Ms. Schofield. Ladies and gentlemen, that's the last witness the state of Tennessee has in this case against Mr. Billy Turner. Cannot discuss the case amongst yourselves, cannot discuss the case with anyone else. We'll take a brief recess, and he talked to Mr. John Keith Perry and Mr. Andre Thomas to see whether or not they choose to present any additional proof on behalf of Mr. Turner. Remember what the court has told you, they do not have to present any additional proof at all. And if they do, you hear from any witnesses that Mr. Perry and Mr. Thomas chooses to call for Mr. Turner. If there are no other witnesses, you have heard all the proof that you will hear in this case. But please do not discuss the case at this point. It would not be appropriate to do so. I need to have those legal discussions out of your presence, and we'll call you back in the courtroom shortly. You can follow Deputy Smith, please. And for the record, the jury is out. Do we have any motions, John Keith Perry or Mr. Andre Thomas, that you want to present on behalf of Mr. Billy Turner as the state of Tennessee has arrested his case in chief?
Your Honor, at this time, I'd like to make a formal JNOV or an alternative judgment of acquittal, motion for judgment of acquittal based on the insufficiency of the evidence in this case, specifically with the state's main witness giving, I think, extremely contradictory testimony throughout his testimony. We are of the opinion that the state has failed to meet the burden to get this case before the jury.
And or Ms. Hagerman and Ms. Schofield.
Your Honor, at this point, it takes the evidence light most favorable to the state. Your Honor has heard from Jimmy Martin, who has laid out a conspiracy to kill Lorenzen Wright that included Billy Turner. Your Honor has heard Mr. Martin testify about statements that both Ms. Wright and Mr. Turner made claiming responsibility for the homicide. Your Honor has seen a large amount of circumstantial proof incriminating this defendant. Your Honor has heard firsthand about the trip Jimmy Martin and this defendant took to Atlanta. Your Honor has heard this defendant make statements that are been called in lies and made statements that tend to incriminate him with regard to details that corroborate Mr. Martin. We have jury questions for this jury. I think all three charges should go to the jury.
And for the record, this is a motion for judgment of acquittal, motion for directed verdict. It says just coffee. Do not believe the state of Tennessee has carried its burden to even submit this case to jury because of the extremely contradictory testimony of Jimmy Martin, and also the lack of evidence that would be allowed to submit this case to jury. When the sufficiency of the evidence is challenged, the relevant question that this court has to make is whether after reviewing evidence in the light most favorable to the state of Tennessee, whether any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt. Federal case, Jackson versus Virginia, 443 U.S. page 307, 1979, United States Supreme Court opinion, and State versus Davis, Davis, 354 Southwest 3rd, page 718, 2011 Tennessee Supreme Court opinion. These are factual issues, as Mr. Perry has indicated, and these are credibility issues, as Mr. Perry has indicated. In the trial court, the credibility of the witnesses, the weight to be given to their testimony, and reconciliation of any conflicts. Mr. Perry has indicated that he believes that Jimmy Martin's testimony has been extremely contradictory. Those credibility issues, the weight to be given to the testimony of the witnesses, and the reconciliation of any conflicts in the testimony are matters that the trier of fact determines. This court does not determine factual issues. As I told the jury on Monday, the jury determines what is factually true, determines whether or not those conflicts can be resolved. And part of the court's charge is that if the jury finds that there is, in fact, contradictory testimony, the jury must reconcile those conflicts if they can, without hastily or rashly concluding that a witness is sworn falsely, because the law presumes that every witness who has testified has, in fact, told the truth. That's State versus Campbell, Campbell, 245 Southwest 3rd, page 331, the 2008 Tennessee Supreme Court opinion. The trial court does not weigh the evidence. If there is a conviction in the case, it's a 13th juror, the court would have to affirm that verdict, any verdict that the jury reached, if there is, in fact, any conviction. But this threshold question, whether or not there is any rational trial fact could find essential elements of this offense beyond a reasonable doubt. There are three essential elements in first-degree murder. Based on the proof that is before the court, Mr. Martin may or may not be charged as an accomplice. Mr. Martin's testimony said he had absolutely nothing to do with the first-degree murder. And if the court does not charge him as an accomplice on that first-degree murder, based on his testimony alone, if the jury believes that testimony, the jury can, in fact, find essential elements of first-degree murder based solely on the testimony of Jimmy Martin. There's also other testimony on the record. Ms. Robinson, who testified as a cousin, this court legally, factually cannot find that she's an accomplice on any of his conduct. Testified she was present in two meetings, rather, in which Jimmy Martin, Billy Turner, Cheryl Wright both talked about plans to kill Lorenzen Wright. Cheryl Wright wanted him killed because she was under the impression that Lorenzen Wright had a hit on her, and she wanted to have him killed before he killed her, allegedly. At least two different meetings, they talked about how they were going to do it, procuring guns and multiple text messages and Facebook messages and other social media messages in which there was code words used as to how this plan was going to be carried out. On the conspiracy, Mr. Jimmy Martin is certainly an accomplice to the conspiracy. Testified that he went there, had a plan to kill Lorenzen Wright, got there, saw a bald-headed person on the couch that he got within arm's length of, and decided that was the wrong person, decided not to kill that person. That testimony has actually been corroborated by Mr. Lorenzen Wright's, who called himself Mr. Wright's best friend. Had known him since grade school and did sleep on the couch in that condo for the 3 months that he lived there, slept on the couch, was very comfortable. Physical description, for the record, totally fits the description that Jimmy Martin gave when he talked about the person who was present on that couch, and they did not carry out that planned killing earlier in 2010. Mr. Martin is obviously a accomplice to an attempted murder. His testimony has been sufficiently corroborated by all the other proof on the case, not only the text messages, but also surveillance that was developed over the course of these years, the physical property that was recovered that corroborated Mr. Jimmy Martin's testimony. In order for a jury to find Mr. Billy Turner guilty of conspiracy, cannot be found guilty of conspiracy based only on the testimony of Jimmy Martin, because he is, in fact, an accomplice to that crime. It has to be corroborated by some other facts, including other factors that go to the identity of Billy Turner. There is more than enough corroborated evidence for a jury to find the essential elements of conspiracy to commit a first-degree murder. Criminal attempt to commit a felony with first-degree murder. Again, Mr. Jimmy Martin necessarily would, in fact, be a accomplice as a matter of law and a matter of fact on that case. There is, again, more than enough evidence that would corroborate what his testimony is. The physical proof, the crime scene location, the things that were recovered at the crime scene, the shells that were recovered, the medical examiner's testimony as to what bullets were found in the decomposing, skeletalizing body of Lorenzen Wright some 8 or 9 days after the shooting, and ultimately the car that belongs to Billy Turner, the red wire cutters that Mr. Jimmy Martin indicated were in fact used to cut this wire. All of that testimony has been sufficiently corroborated, and these are strictly factual credibility issues that a trial fact that a jury has been obligated, has been charged with resolving, and based on all of that and for the reasons stated, the court will in fact deny the motion for judgment of acquittal. These are 100% jury questions that this jury will in fact resolve if they can as to whether or not the state has proven beyond a reasonable doubt into a moral certainty that Mr. Martin is guilty of first-degree murder, conspiracy to commit first-degree murder, and whether or not he's guilty of criminal attempt to commit first-degree murder. I will deny the motion for judgment of acquittal for all of those reasons. Mr. Perry, Mr. Thomas, we'll take a recess for a minute and give you a chance to talk to Mr. Billy Turner to see whether or not he's made a decision as to whether or not he will, one, present any additional testimony, and secondly, whether or not he's chosen to testify. And before we start, we'll conduct that moment hearing, or resume rather, we'll conduct the moment hearing as to whether he chooses to testify as a witness or not. You'll also talk to Mr. Turner about the conference that we had at the bench on the lesser included charges based on statutes of limitations. The court's opinion is on Class A felonies and greaters, first-degree murder, Class A felonies, the statute of limitations is 15 years. On a Class B felony, statute of limitations is 8 years. On a C or D felony, statute of limitations is 6 years. And on an E felony and misdemeanors, it will be less than that. 2 years on an E felony, 11 months and 29 days on a misdemeanor. This conduct allegedly occurred in 2010. The prosecution commenced when the indictment was returned by the grand jury in 2017 for a C or D felony, 4 years, 2 years for an E felony, 11 months and 29 days for misdemeanor. For the court to charge any lesser included offenses any offenses other than a Class A felony or B felony, Ms. Turner would have to waive his statute of limitations, waiving any claims as to the prosecution of convictions on those D felonies or C felonies or less. He would have to waive the statute of limitations, otherwise the court cannot charge that. So if he wants the court to charge something other than a B felony or an A felony, he would have to waive that, and also need to talk to Ms. Turner once you had a chance to discuss it with him to see whether or not he wants to waive the statute of limitations or submit it to the jury on only A and B felonies. Anything else before we take a recess so that Mr. John Keith Perry and Mr. Andre Thomas can talk to Mr. Turner?
No, not from us, Your Honor.
We call the court to recess. We can ask the courtroom to be cleared, and we'll resume shortly, please. Perry, Mr. Andre Thomas, have you had a chance to talk to, sufficient time to talk to Mr. Turner as to whether or not he, one, chooses to testify as a witness on his own behalf, and whether he wants the court to consider charging lesser included offenses that would not be covered by the statute of limitations normally?
Yes, sir. The first request, he will not be testifying, and if the court wants to voir dire him on his choice, he's available for that. And on the second, we are going to waive any objection to statute of limitations issue.
We'd like to conduct that moment. Board, I just want
Yes, sir.
Mr. Turner, come around, please, sir. Come around to your left. Mr. Turner, good morning. Good morning. Raise your right hand, please, sir. Do you solemnly swear or affirm that the testimony you will give in this hearing will be the truth, the whole truth, and nothing but the truth, so help me God? Thank you, Mr. Turner. Yeah, now come see right here, sir. Right step, please. Mr. Turner, good morning. If you will, please state your name for the record and spell it for the court reporter, please, sir.
Billy Turner, BILLYTURNER.
Mr. Turner, this is what is referred to as a moment hearing, okay? Mr. Perry and or Mr. Thomas are going to ask you some questions about whether or not you choose to testify as a witness in the case. You understand that, sir?
Yes, sir.
Prosecutors will not be able to ask you any questions at all. Mr. Perry is not going to ask you anything about what happened, and Mr. Thomas will not ask you anything about what happened, what you did, or what you did not do. They will not ask you those questions at all. So listen to the questions that Mr. Perry will ask of you. Make sure you answer those questions. Don't volunteer anything. Don't say anything about what might have happened. You understand that?
Yes, sir.
You have any questions, sir?
No, sir.
Mr. Perry, you may proceed.
Thank you.
Yes, sir.
Mr. Turner, please, you've been here throughout the full week of trial, correct?
Yes, sir.
And at all critical moments, you've been present in the courtroom, right?
Yes, sir.
As well, we've had conversations regarding the right to testify.
Yes, sir.
And you also know that you have a right to not testify.
Yes, sir.
Based on our conversations and the representations of counsel, the advice of counsel, have you made a decision regarding testifying?
Yes.
What's your decision, sir?
I do not want to testify.
And you ready to go forward with the case?
Yes, sir.
Do you have any? Do I need to ask him anything additional, Your Honor?
No, sir.
All right, thank you.
Mr. Turner, what Mr. Perry just told you is that this is your right. You understand that, sir?
Yes, sir.
This is 100% your choice. You understand that?
Yes, sir.
Now, what Mr. Perry has told you and what Mr. Andre Thomas has told you is that, well, two things. Let me cover two things. Back up a little bit. Nobody can call you as a witness. You understand that?
Yes.
I think you ever tell the jury that on Monday. Nobody can call you as a witness. Nobody can prevent you from testifying. Mr. John Keith Perry, Mr. Andre Thomas will give you advice, give you opinion as to whether or not they think it might be a good idea or a bad idea.
Yes, sir.
They'll cover those things that could be possibly good for you, some things that could possibly be bad for you, the advantages and disadvantages of testifying or not. You understand that?
Yes, sir.
Their advice does not control what you do. You understand that?
Yes, sir.
If you tell me that Judge Coffey, I want to testify, you'll be allowed to testify. If you tell me that Judge Coffey, I made this decision, it's a personal decision, not what your lawyers want to do, but what you want to do. You made a personal decision to remain silent and not testify in this trial. That is 100% your decision. You understand that?
Yes, sir.
Mr. Turner, if you made a decision to testify, I would tell that jury, they will look at it. They will evaluate your testimony just as they would any other witness. You understand that, sir?
Yes, sir.
If you made a decision to remain silent and not say a word, I would tell that jury they cannot hold it against you for any reason at all. They cannot draw any inferences from the fact that you chose to testify, and they cannot think or even speculate as to why you made the decision to remain silent. You understand that?
Yes, sir.
And this is 100% your decision. You understand that?
Yes, sir.
And actually, that was Turner, because in almost 16 years of trying cases, people sat in that witness stand and they tell me, Judge Coffey, I decided not to testify, or Judge, I decided to testify. Then they'll come back a week later, a month later, a year later and say, Judge Coffey, I really wanted to testify. My lawyer would not let me testify, so I really wanted to testify, but I didn't because my lawyer would not let me. So this is your decision. You understand that?
Yes, sir.
Now, you're telling the court, you told Mr. Perry that you have made the decision not to testify. Has anybody threatened you, promised anything, put any force or pressure on you in order to get you to make that decision, Mr. Billy Turner?
No, sir.
You have any questions you want to ask the court, sir?
No, sir.
Mr. Turner, I know you told me you couldn't wait to get your day of trial. I'm glad we were able to try this case for you this week, sir.
Yes, sir.
Thank you, sir. You sit down. I wish you good luck in the rest of the trial, sir. And for the record, pursuant to Mullen MOMON versus State 18 Southwest 3rd, page 152. A 1999 Tennessee Supreme Court opinion, I find for the record that Mr. Billy Turner understands that he has the right to testify or not. Mr. Turner understands that this is 1% his personal decision. I find that Mr. Perry and Mr. Thomas have advised Mr. Turner about the possible benefits, the advantages, the disadvantages, the good, the bad that could result in his making a decision to testify or not. And I found that Mr. Turner has personally, knowingly, voluntarily waived his right to testify and present evidence on his own behalf. And I will in fact charge the jury that Mr. Turner is presumed to be innocent of these charges against him, that he's not required to take the stand on his own behalf, and his election not to testify cannot be considered for any purpose against him, nor can any inference be drawn from the fact that he chose to remain silent and not testify in this case. Mr. Turner, stand up for a second. I apologize to you, sir. Come back, take the witness stand for a second again. I need to ask you some other questions on other issues, and I apologize for not taking care of that when you were on the stand a minute ago. You can have a seat, Mr. Turner. You're still under oath, and I apologize to you for having to call you back to the witness stand. But before we took a break, I talked to you about the statute of limitations, and that's a lot of words. And what it means, Mr. Turner, is that in order to be prosecuted for certain crimes, the state of Tennessee has to initiate the prosecution within a certain number of years. This conduct occurred allegedly back in 2010, and for a Class A felony, the state has 15 years to initiate the prosecution. So those Class A felonies, murder, attempted murder, conspiracy, those are included within the statute of limitations. You understand that?
Yes, sir.
B felonies, there are 8-year statute of limitations. There are some other included offenses that the court could charge, and I will charge if you tell me it's okay with you. Class C and D felonies, that prosecution has to be commenced within 4 years. On an E felony, it's 2 years, and on any misdemeanors, it's 12 months. I think it said 11 months, 29 days. It's just a year, 12 months in Tennessee.
Yes.
And in order for me to charge those crimes, lesser crimes, to get a jury the option, if they find that you're not guilty of the greater crimes, they can be given other options about lesser crimes. For instance, on the first-degree murder, necessarily included under Tennessee law for first-degree murder would be the included offenses of second-degree murder, which is a Class A felony. Also, facilitation of first-degree murder, facilitation of second-degree murder, voluntary manslaughter, which is a Class C felony, facilitation of voluntary manslaughter, it's a D felony, reckless homicide is a D felony, criminally negligent homicide is an E felony. All of those included offenses, anything less than a B felony, I cannot charge the jury on that. They cannot consider it. You understand that?
Yes, sir.
The only way I can charge the jury on that, Mr. Turner, is if you tell me that Judge Coffey, I am waiving the statute of limitations. I want you to charge all possible included offenses on all counts of the indictment, and it gives the jury a greater range of options as to offenses they can consider. But I can do that only if you tell me it's okay. You understand that, sir?
Yes, sir.
And are you asking the court to waive the statute of limitations for C, D, E felonies, possibly misdemeanors, and charge everything that could possibly be included in your case?
Yes, sir.
And have you talked to Mr. John Keith Perry and Mr. Andre Thomas about that?
Yes, sir.
You have any questions about that? Because I know it's a lot of legal words. You have any questions about it?
No, sir.
And is this also what you want to do?
Yes, sir.
Has anyone threatened you, promised anything, put any force or pressure on you in order to get you to make that decision?
No, sir.
You have any questions about the court, about the statute of limitations or those included offenses?
No, sir.
Thank you, Mr. Turner. Step down again. I apologize, sir.
All right.
And this court will find pursuant to State versus Pearson, Pearson, 858 Southwest 2nd, page 879. This is a 1993 Tennessee Supreme Court opinion that dealt with the issues of lesser included offenses and statute of limitations. Supreme Court in the state of Tennessee has held that the statute of limitations is waivable, that it is waivable because it is not jurisdictional. But in order for the court to charge those lesser included offenses, anything less than a B felony, C felonies, D felonies, Class E felonies, the court has to find that Mr. Billy Turner has knowingly and voluntarily waived his right to have the jury to consider those offenses which in fact would fall outside of the statute of limitations. And again, for C and D felonies, statute of limitations will be 4 years, for an E felony 2 years, for a misdemeanor 12 months. And this court has conducted hearing according to the Pearson case and made sure that Mr. Turner has been advised of his rights to say, Judge Coffey, I do not want the jury to consider those lesser offenses, and if I don't have this hearing, if I charge those offenses and the jury comes back with a verdict on some lesser charges, the Pearson case and other cases would say that it is a void conviction because there's nothing on the record that would indicate that Mr. Turner was advised of and apprised of the statute of limitations and the consequences of waiving that statute of limitation. This has been intelligently and knowingly waived by Mr. Turner because it is possibly in his benefit, and he has made the decision after consulting with the counsel, and it does not contravene rather public purpose and the purpose of the statutes to allow Mr. Turner to say, Judge Coffey, I'm willing to waive the statute of limitation on lesser charges, and it gives the jury a wider range of options that they can consider if a jury finds me guilty of any conduct, and I'm not presupposing that a jury will convict Mr. Turner of anything, but I'm finding that he's waived the statute of limitations, and I will in fact charge all possible lesser included offenses on all 3 counts of the indictment. Your next witness, Mr. Perry or Mr. Thomas, will be if you choose to present any additional proof.
Yes, Your Honor. Ms. Jennifer Bogan.
Yes, sir. Are both sides ready to proceed?
Yes, sir.
Deputy Smith.
Yes, sir.
Bring in the jury, please, sir.
Yes, sir.
Yes, sir. Thank you, ladies and gentlemen. Everyone can be seated. Ladies and gentlemen, the jury of the state has rested this case. And as I told you a few minutes ago and told you on Monday, if Mr. Turner, through his attorneys, Mr. John Keith Perry and Mr. Andre Thomas, choose to present additional proof, they may do so, but they're not required to present any additional proof. Does everyone still understand that?
Yes, Your Honor.
Mr. John Keith Perry, do you have an additional proof on behalf of Mr. Turner at this time, sir?
Yes, sir, Your Honor. I'd like to call Ms. Jennifer Bogan.
Jennifer Bogan, please. Ms. Bogan, come around through the door over here to your left. Walk into where Deputy Smith is seated on the standing by the seal of Shelby County, Tennessee. And once you get here, Ms. Bogan, if you place your left hand on the Bible, please, ma'am, and raise your right hand to be sworn, please. Ms. Bogan, do you solemnly swear or affirm the testimony you will give in this case will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you, Ms. Bogan. Put your hand down. Have a seat here. Watch yourself, please. Good morning.
Good morning.
Ms. Bogan, if you want to, you may remove the mask, and if you want to keep it on, you may do so also. I had a hand up from one of the jurors. Two of the jurors, yes. Come in, Deputy Smith. Sorry, yes, sir. Mr. Perry, my apologies. You may proceed.
Thank you, Your Honor. Please state and spell your name.
Jennifer Bogan, and it's JENNIFER BOGAN.
Back in 2010, what was your address?
494 South Main Extended in Collierville.
Collierville, Tennessee.
Yes, correct.
Drawing your attention to the month of July, is there a particular date in July that sticks out in your mind each year?
The 18th
The 18th?
of July.
And I know you're soft-spoken, but we got a court report, so you got to speak up where they can hear you as well. But July 18th, 2010, was anything going on particularly that weekend?
Yes, I had a cookout that weekend.
All right. What day or days?
Saturday and that Sunday.
All right. And that Saturday would have been July 17th?
Correct.
And how did you end up having 2 days of cooking out?
That Saturday, we had the cookout started, and then that Sunday, since I had leftover food, I invited my church members over that Sunday.
What church was that?
Mount Olive, number 1.
And do you know of Billy Ray Turner?
I do.
How do you know Mr. Turner?
He's a family friend and also a church member.
And how long have you known him?
At least about 20 years, I would say.
And on that particular day, or that weekend, did he come to your home as a visitor?
He did.
Which day?
On Sunday.
That would have been July 18th?
Yes, correct.
Do you remember around what time he would have come to your home?
I would say early afternoon after church.
Maybe 2 or 3 o'clock?
Correct.
You know, may I post
Yes, sir.
this? Have the copy. I'm going to ask you to identify what you see in those photos, and then I'm going to pass the photographs to the judge. But hold on. Did you?
Did you need me to take a look at it?
No. Well, I didn't know if.
I have a request.
Okay.
That we'll deal with in a few minutes, but it's not anything relative to anything else that's going on right now. It's a scheduled request.
Yes, sir.
Yes, sir. Thank you, sir.
All right. On the first photo, what is that on that first page?
It is a photo of my backyard with some of my church members sitting around at some tables I had set up in my backyard.
I asked you about a person a few moments ago, Mr. Billy Turner. Do you see him?
Yes.
And where is he depicted on that photograph?
He's sitting at one of the tables.
And what does he have on?
Red and white stripy shirt.
All right, and can you turn the page to the next page, please? What's depicted in photograph number 2?
Some of the members that was at the party sitting at a table on the outside up under the carport at nighttime.
All right.
Playing cards.
Now, in that photograph, is Mr. Turner present during that photograph?
He is not.
Now, is he still in your home from your memory at the time that photograph would have been taken?
I would believe so.
And I'm going to ask you about the next photograph, please. What's depicted in that photograph?
Myself holding up one of my birthday gifts, and Mr. Turner is in the background of the picture.
And is that later in the evening also?
Yes, I opened my gifts toward the evening of the day.
I'd ask that those be passed to the judge.
Ms. Schofield, with Mr. Hagerman, any objections to this offer of proof?
No objection, Judge.
Exhibit 104-104. Photograph described by Ms. Bogan as a photograph of church members at a table during this cookout, with Mr. Turner pictured in a red and white shirt. Exhibit 104, church members at a table. Exhibit 105, photograph described by Ms. Bogan as showing church members at a card table. Exhibit 105, and for the record, Ms. Bogan indicates Mr. Turner is not in that photograph. Exhibit 106, photograph described by Ms. Bogan as a picture of her holding one of her birthday gifts, with Mr. Turner pictured in this photo. Exhibit 106, Ms. Bogan holding a birthday gift.
Mr. Bubba, Your Honor.
Yes, sir, you may.
Pass it down. Thank you. That's all. Now, in those photographs, I'm sorry.
I would love it if you talk mostly, you're going to lose the interest and attention of the jury if they're looking at pictures you're talking at the same time.
Yes, sir, Your Honor.
Not a problem. Well, you need a glass of water. Okay, you're all right. Okay. Ms. Perry, you may proceed.
Thank you.
Yes, sir.
During that afternoon and evening, approximately how many people were in your home?
I would say at least 20, maybe. So,
And they were engaging in different activities in the home and
Yes.
outside.
And inside and outside, yes.
Do you remember if Billy was engaging with other people in the home?
Yes, he was engaging with the guests there. He was playing basketball outside with some of the teenage boys and my sons.
And during that evening, there was one of the photographs that he's not actually depicted, but there are people that are sitting around a table.
Mm-hmm.
Where's that table area?
It's outside in front of the carport.
And do you remember approximately when Billy would have left your home?
I would say around 10 or a little bit after 10 because I started cleaning up then.
Do you remember if he helped with the cleanup procedure?
He did.
Of the guests that were there, what was his, I guess, order of leaving? Was he one of the last to leave?
Yes.
And you said he helped clean up. What all was he? How was he helping you clean up?
When I started to move around and shut down, he was just known to start helping clean up with the tables, stuff like some of the tables that I had there.
And during the course of that day or evening, did he sing himself like you normally know him?
Yes.
All right. And can you tell us what you normally know when you see him?
Very festive, joking, interacting a lot with the children. He's kind of like a mentor to some of the little teenage boys that was there. Just being himself.
Was there anything odd or rushed about him or nervous acting about him at all?
No.
And you said that he was one of the last to leave, and he did help you clean up everything.
He did. Mm-hmm.
Your Honor, may I approach? Yes, sir. A few moments ago, I asked you about your address. What was the address back then?
494 South Main Extended.
All right, and in that, I just handed you a map. Do you see where your address would be on that map?
Yes. Over here.
Is that where the dot is?
Yes.
And you see a line drawn to another address.
Correct.
Can you read the address that line is drawn to?
4530 Whisperwoods Drive in Collierville, Tennessee.
All right. Are you familiar with that address?
I am.
All right. And do you know a Shira Wright?
I do.
How do you know Shira Wright?
She was also a member of my church.
Now, was she at your party during that evening that you remember?
She was not.
And you see the distance. Does it mark a distance on there?
Yes.
What is the distance that it's saying between those two homes?
2.12 miles.
And you have any explanation to it? Yeah, I'd ask if that could be marked as the next exhibit, please.
Any objections to tagging on this?
I think the last page may be blank.
So these two you want admitted as a joint exhibit, Mr. Perry?
Yes, sir.
Yes, sir. Ms. Bogan, when Mr. Perry asked you about a circle and you pointed to something, you showed it to me, but it may be difficult for the jury to get an appreciation for what that was.
Okay.
So I'm going to give you a red marker.
Okay.
And if you could put a red marker around the circle that you identified as your house, that would probably help the jury. Okay. Yes, sir. Thank you. It's fine. That's fine. It's perfect. Because I could barely see it, and if we showed it to the jury, they would not be able to see it. Okay.
Permission to publish it.
Yes, sir. This is exhibit number 107. a Google map identified by Ms. Bogan as showing a location of where her house was on 494 South Main extended in Collierville in relation to an address of 4530 Whisper Woods. .4530 Whisper Woods Drive in Collierville, Tennessee. A distance that Ms. Bogan says is about 2.12 miles distance between her house and the house in Whisper Woods. A Google map, exhibit number 107. You want to have that handed to the jury, Mr. Perry?
Yes, Your Honor.
Deputy Smith? Perry, you may proceed.
Sir, just a few other questions. You said that during that evening that he was cleaning at the conclusion of the party, and based on your memory, you think he was one of the last or the last person visitor to leave. Mm-hmm. And in the home, is that anything that would have been out of the ordinary for him to do to try to help?
No, he was always helping. That's just his character, to help.
I don't have anything further.
Mr. Hagerman, you may proceed.
I just have a couple of questions. Ms. Bogan, I've met your dad before. He had us to his house.
Oh, okay.
And he's a nice man. And
Just a couple questions.
You said that Mr. Turner would have left around 10-ish? Is that right? Okay, so with regard to your personal knowledge, what you actually know from your personal knowledge, do you know where Mr. Turner was at midnight?
I do not.
Any idea where he was 12 minutes after midnight?
I do not.
Any idea where he went after he left your house?
I do not.
From your personal knowledge, do you know about his relationship with Sharon Wright?
I do not.
At the time that these events happened, way back in 2010, did you know that Billy had a car and a truck?
Yes.
And did you know that Billy had taken a trip to Atlanta?
No.
I've never heard the question.
Okay, well, thank you. Ms. Perry, any additional questions?
Would it have been odd for Billy to loan his car to anybody?
He was always doing whatever he can to help anyone.
I don't have anything further, Your Honor.
Ms. Hagerman. Ms. Bowden, thank you for being in court on Saturday morning. I'm going to excuse you for any additional testimony in this case, ma'am. You can stay and watch the rest of the trial if you want to, if you're able to do so, but you cannot discuss what you testified in court with anyone or allow anyone to talk to you about the other witnesses' testimony.
Okay.
Thank you. Step down and watch your step, please, ma'am.
All right, thank you.
Thank you, ma'am. Counsel, approach, please. Ladies and gentlemen, I got a question from one of your members while Mr. Bowden was testifying. I told you in those preliminary instructions that you might submit a question to the court, and I can't answer it. Can't ask it. Can't have a witness answer it. If that witness probably would not be able to answer that question, I'm not going to submit it to the witness. So whatever the question was, don't discuss it with your other jury members. Don't take it into consideration for any reason at all. If that question that was submitted by a member of the jury has been answered by other proof in the case, you may consider the question an answer. But if not, please disregard the question and don't discuss the question with other members of the jury. Mr. Perry and Mr. Thomas, do you have any additional proof?
No, Your Honor. The defense rests.
State, Mr. Hagerman, Ms. Schofield, do you have any rebuttal proof?
We have no rebuttal proof, Your Honor.
Ladies and gentlemen, you heard all of the proof that you will, in fact, hear in this case. It's 11:30, and what I need to do next, I need to talk to the lawyers about the jury charge. I told you on Monday that it would be about 30 pages long. It's about 30 pages long. I need to talk to the lawyers about things that they might want included, things that they might not want to have excluded in the charge, rather. And we'll conduct that charge conference. It has to be done outside of your presence. We'll discuss another legal issue or two with the attorneys. And I'm going to make 22 or 23 copies of this charge. And this afternoon, I'm going to read this law to you. We're going to present the law to you. We'll talk about other scheduling issues once the charge is being presented. And I got a note from one of your members that indicates, is there any way that we can resume on Monday after today? Sunday is a religious day for me, if it is possible. And what I told you on Monday, that we will work on Sundays only if all the jurors say Judge Coffey, that's fine with me. But if somebody tells me the judge is religious and really have a religious objection on working on Sunday, we would not hold court on Sunday. We would charge this case today. We'll reach all the law that could possibly apply in this case. And the lawyers will have three different arguments they can probably present to you. State of Tennessee will present a closing argument. Mr. Turner's attorney, either Mr. Thomas or Mr. Perry, will present an argument if they choose to do so. And if they do choose to do so, the state can present a rebuttal argument. As I told you, I cannot limit lawyers' arguments in Tennessee. The law says, Judge Coffey, you have to give lawyers a reasonable time, adequate time rather, but not an excessive time. Now, of course, it never really defined what is adequate and what is excessive. So those arguments might take an hour and a half. They might take 3 hours. Collectively, might take longer than that. So it would be imprudent to argue the case and then have you start deliberating today, because I don't want you to think that we have to rush through a decision and we want to get out of here on Saturday and we're just going to reach a decision on this case so we can get this over with. And what I told you on Monday and what I told you on the 4th of March, when I saw you at the jury assembly room at 157 Poplar on March 4th, that this case probably lasts somewhere between 7 and 10 days. The lawyers have been really efficient. This is day 6, and all the proof has been heard. You hear all the law, so you're actually way ahead of schedule, because I thought we would be here until Wednesday or maybe Thursday or Friday of next week. You will hear this case. You will be hearing arguments on this case, and this case will be in your possession. To make a decision whether or not Mr. Turner is guilty or not guilty, that will be in your possession on Monday. And we are at least 2 or 3 days ahead of schedule. And I will give deference to your member or members who say, Judge Coffey, I really don't want to work on Sunday. Can we resume this on Monday? I will give deference to the will of the jury. And if one person tells me that, it is a 100% democracy, and we will charge this case today as soon as I talk to the lawyers about what they want included or not. And we'll give you all the law on the case, and we'll start jury arguments at 10 o'clock on Monday morning. Have to qualify grand jury at 9 o'clock. We change grand juries every third Monday on alternate months. So Monday morning at 9 o'clock, I will qualify 24 of your fellow citizens to serve on a grand jury for Tuesday and Thursday for the next 2 months. And at 10 o'clock, we'll start arguments on this case. You still cannot discuss the case with anyone or amongst yourselves, and we'll start reading this law to you in a few minutes. If your lunch gets here before we conclude this jury charge conference, don't have you eat lunch, and we'll start reading the charge to you after the lunch break. You can follow Deputy Smith, and I'll see you in a few minutes, or I'll see you in about 2 hours. Thank you all. So I guess the discussion we had this morning, we can hear that door to close, I'm sorry. And now for the record, the jury is out. The discussion that we had this morning about scheduling, I guess that question has been definitively, conclusively answered by the jury. And we'll read the question for the record as it is written, quote, is there any way that we can resume on Monday after today, exclamation point. Sunday is a religious day for me, period. If it is possible, period. So at least one of the jurors have told me in writing, which has never happened before, that Judge Coffey really don't want to work on Sunday. We would rather resume on Monday. And I would defer to the will of that jury, and we will charge this case, fully charge the case, and on Monday morning we'll start arguments at 10 o'clock a.m. as indicated. I have to swear in the next March term of the grand jury for the next 2 months, and they'll still be here on Monday morning at 9, and we'll start jury arguments promptly at 10. Both sides having arrested and closed this proof. Mr. Perry, Ms. Thomas, do you have any additional motions on behalf of Mr. Turner?
Your Honor, I would just like to renew my motion for the written verdict.
Mr. Hagerman.
Same response as before, Your Honor. Ask Your Honor to deny the motion.
And the court will incorporate the rulings that are made at the end of the state's proof. Both sides have arrested and closed. The court still is firmly of the opinion that this is a factual issue and a credibility issue that should be resolved by this jury, and the court will deny the motion for judgment of acquittal. What the court intends to charge in the case, and it's indicated I've been working on this charge since February 28, 2019. That's when I started drafting this charge, and I made some revisions as this week has gone on. We'll charge and count one of the indictment, the indicted charge of first-degree murder. And at the request of Mr. Turner, waiving any possible objections to the statute of limitations, the court will also charge second-degree murder as an included offense, facilitation of first-degree murder, facilitation of second-degree murder, voluntary manslaughter, facilitation of voluntary manslaughter, reckless homicide, and criminal negligent homicide. Will not charge facilitations of reckless and criminally negligent homicide, because Tennessee law is that you cannot intend a reckless or negligent act, so facilitation would not be an included offense of those charges. We'll charge conspiracy to commit first-degree murder in count 2 of the indictment, facilitation of conspiracy to commit first-degree murder. Count 3, criminal attempt first-degree murder. The included offenses of facilitation of criminal attempt first-degree murder, criminal attempt second-degree murder, facilitation of criminal attempt second-degree murder, criminal attempt voluntary manslaughter, and facilitation of criminal attempt voluntary manslaughter. Would not charge attempted reckless homicide or attempted criminally negligent homicide, because again, Tennessee law says you cannot intend to commit reckless or negligent acts. So those are the court's intentions to charge the greater offenses, charge offenses, and the included offenses. Will also charge criminal responsibility for the conduct of another. As indicated earlier, those included offenses will charge criminal attempt for the conduct of another, telling the jury that a defendant is criminally responsible for an offense may be found guilty not only of that offense, but also for any other offense or offenses committed by another. If you find beyond a reasonable doubt that the other offenses or offenses committed were natural and probable consequences of the original offense, defining for the jury what criminal responsibility is, and responsible for an offense committed by the conduct of another if acting with the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense, the defendant solicits, directs, aids, or attempts to aid another person to commit the crime. We'll also tell the jury that to find the defendant guilty of criminal responsibility for the acts of another, it is not necessary that you find the defendant took a physical part in the crime. Encouragement of the principal offender is sufficient. However, mere presence during the commission of the offense is not sufficient to support a conviction. Would charge facilitation of a felony offense as indicated earlier. We'll give the jury a long charge on identity. Those other charges that we're required by law to charge: presumption of innocence, reasonable doubt, burden of proof, direct and circumstantial evidence, impeachment of a witness, prior consistent statements, a long charge on witness credibility. We'll also charge the witness on accomplice and what accomplice testimony is, and what or who might be an accomplice in this case. For the record, accomplice, our court, Supreme Court, Court of Criminal Appeals, has defined an accomplice as someone who knowingly, voluntarily, and with common intent participate with a principal offender in the commission of a crime alleged in the charge and indictment. Among other cases, State versus Griffiths, Griffis, 964 Southwest 2nd, page 877, 1997 Court of Criminal Appeals opinion. And the court has to make that threshold decision originally. And the question, among other things, is whether or not the witness status as an accomplice is answered by determining whether that person could have been indicted for the charge offense. Tennessee case law would also indicate that if the facts about the witness participation in a crime are clear and undisputed, the trial court should determine as a matter of law whether the witness was an accomplice. However, if the facts are disputed or subject to different inferences, the jury should determine as a matter of fact whether the witness was an accomplice to the commission of these alleged offenses. And among other things, the State versus Robinson, ROBINSON, 239 Southwest 3rd, page 211, 2006 Court of Criminal Appeals opinion. And because of that, the court will, in fact, charge the jury that Jimmy Martin is, in fact, an accomplice in the alleged offenses of criminal attempt first-degree murder and conspiracy to commit first-degree murder, and that a jury cannot convict Mr. Billy Turner on the uncorroborated testimony of Jimmy Martin for those offenses of criminal attempt first-degree murder and conspiracy to commit first-degree murder, and that the accomplished testimony, in fact, must be corroborated, and accomplished testimony cannot be corroborated by another accomplice's testimony. We'll also charge the jury that it is a question for the jury to determine whether the witness, Jimmy Martin, was in fact an accomplice in the alleged offense of first-degree murder. And if the jury finds that he was in fact an accomplice, then the defendant cannot be convicted upon the uncorroborated testimony of Jimmy Martin. And if they find that he was in fact not an accomplice to the first-degree murder, then the jury would judge the weight to be given to his testimony just as it would any other witness in a case. And again, the court is the gatekeeper of that decision on finding that based on the record, based on the proof that is before the jury, that Jimmy Martin is in fact an accomplice to attempted first-degree murder and conspiracy to commit first-degree murder. Do not find, as a matter of law, that he is in fact an accomplice to first-degree murder because his role in that offense or the commission of the offense is in fact not clear. It is in fact subject to different interpretations as a factual issue as to whether or not the jury wants to believe Mr. Martin or whether they want to believe that he was in fact a party to all of this. And that is a question for the jury to make in the case, and I would give that question to the jury and have the jury determine whether or not he is in fact an accomplice. I would not charge Claudia Robinson as an accomplice to any of these indicted charges. There is absolutely nothing on the record that would indicate that Ms. Robinson knowingly, voluntarily, and with common intent participated with a principal offender in the commission of these crimes that are alleged in indictment. Ms. Robinson indicated she was present at two meetings in which Mr. Martin, Mr. Turner, Ms. Wright had discussions about killing Lorenzen Wright because Shara Wright believed that Lorenzen Wright was going to have her killed. Ms. Robinson indicated that she thought that Ms. Robinson was, Ms. Shara Wright, rather, her first cousin, was not being serious, that she told her that she did not believe Lorenzen Wright would try to have her killed. They had children, thought she was not being serious about that at all, and that she basically blew it off and left. Even after Ms. Wright allegedly made statements that it's either him or me, and he has to be gone. On the second conversation, Ms. Robinson indicated she was present when this conversation again took up amongst those three people about having Lorenzen Wright killed. And her response was not an exact quote because I'm not transcribing the record, but what I wrote down is that, quote, "I can't believe he has a hit out on me. He wants me gone." Allegedly is what Shara Wright said. And Ms. Robinson said she again tried to discourage her from making those statements, did not believe that it was true, and at some point said that Mr. Billy Turner indicated whether or not Shara Wright thought she was going to be a problem. And Shara Wright responded allegedly, no, she can be offed too. And when she heard that, she was pregnant with her first child, and she decided that she was leaving, decided not to have any more contact or communications with Shara Wright, did not report it to anybody because she feared for her safety and the safety of her unborn child, and did not report it because she said, especially when she found out that Mr. Lorenzen Wright had been killed, that if this woman just had her husband, ex-husband, the father of many of her children killed, and she's already threatened to have me offed also, what in the world do you think she would do to me? So there's absolutely nothing on the record that would show that Ms. Robinson knowingly, voluntarily, or with any common intent participated with any of these three people in a planning, the execution of any overt steps that would indicate Ms. Robinson is in fact a accomplice to any of the actions that were taken, if any, by Mr. Billy Turner, Shara Wright, and Jimmy Martin. So I would not charge Ms. Claudia Robinson as an accomplice. Her testimony would be considered without any need for anyone to corroborate anything that Ms. Claudia Robinson may have testified to. We'll also charge the jury. Yes, sir. I will give you a chance to respond. Just telling what I intend to charge, and anything else that you want to object to, you are free to object. We'll charge evidence of other acts, indicating if the witness, they find the witness that's engaged in other acts who have been charged with other crimes, they can consider such prior acts only for the purposes of effect, if any, on the witness's credibility. We'll charge the jury on expert witness. We'll charge the jury on Mr. Turner's election not to testify. We'll also charge the jury on omissions against interest. Any prior statements that may have been attributed to Mr. Turner, either through witnesses or oral statements that he gave to the police, we'll charge the jury on that. We'll also charge the jury on stipulations, charge on jury notes, charge on no outside communications, and a unanimous verdict page. Those are the first 24 pages of the charge. The last 5 or 6 pages relate only to what verdicts the jury can reach and how they go about recording that verdict. And I know you have an objection, Mr. Thomas. You may proceed with any objections or any recommendations that you want the court to consider charging.
Can I apologize for the interruption?
It's okay.
When you were speaking about Claudia Robinson, when she heard about her being a problem and she can be off, you said that Billy Turner said that when actually it was Jimmy Martin.
If I said that, I misspoke, and I apologize.
Yes, sir.
I apologize if I said that I misspoke. Those words were Ms. Shara Wright's words, allegedly. So if I said Mr. Turner, that was a misspeak on my part, and I do apologize to you, Mr. Perry, and Mr. Turner. It is clearly something that Ms. Shara Wright allegedly said as to why Claudia Robinson decided not to report it to anybody because of her cousin had allegedly just had her husband killed, ex-husband. She had no hesitation that Ms. Wright would have her killed also. So it's not words that Mr. Turner said. Those are words attributed to Shara Wright. If I said anything else differently, charge it to my head, not my heart. It was just misspoke on my part. Any objections to what has been proposed by Mr. Perry or Mr. Thomas? Any recommendations? Is anything that you might want included?
No, Your Honor.
I thought about charging alibi. Did not charge alibi because the last witness who testified really did not present. Ms. Bogan did not present an alibi for Ms. Turner. She indicated that she last saw him about 10 o'clock at night. Shara Wright's house is 2.12 miles from her house and has no idea where he was before midnight and after midnight, so it's really not an alibi. So I will not charge alibi for those reasons because it's not been properly raised by the proof in the court's opinion. Mr. Hagerman.
The only question I have is on your criminal conspiracy charge.
Yes, sir.
Tennessee pattern jury instructions extend to 2 pages. I wanted to sort of see your charge to make sure we have the entirety of that included. The second page, conspiracy is a continuing course of conduct, which outlines some details of the charge I think are important.
I'm going to go put this on speed blast. So I will try to read it so the court reporter can follow because I'm told that I talk real fast sometimes. Any person who conspires to commit an offense is guilty of a crime. For you to find the defendant guilty of criminal conspiracy, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the defendant entered into an agreement. Basically, what those first 4 things that I will read is exactly what is contained in the preliminary jury instructions that I gave the jury. So those first 4 essential elements are exactly what the jury has already heard. And we'll follow that up with the term intent has been defined in the definition of intentionally in the first-degree murder instructions. Conspiracy is a continuing course of conduct which terminates when the objectives of the conspiracy are completed or the agreement that they be completed is abandoned by the person and by those with whom the person conspired. The objectives of the conspiracy include, but are not limited to, escape from the offense, distribution of the proceeds of the offense, and measures other than silence for concealing the crime or obstructing justice in relation to it. And we'll also define for the jury what the elements are first-degree murder are, which have already been set out and explained in count 1 of the instructions. So that's what the court intends to charge. Is there anything else the state believes should be charged?
Yes, sir.
Any other objections or recommendations from the state?
Yes, sir.
We'll print this charge and we'll provide it to the lawyers. And once it's been printed, hopefully we'll not have any further objections because I don't want to print 25 more copies. And is jury's lunch here yet, Deputy Phillips? Should be here around 12. We'll print the charges, allow the lawyers to look at it, and juror's lunch will be here at about 12. So as I told the juror, we'll bring it back in the courtroom, or we'll send them about 2 hours, and we will start charging this case at 1:30, because it's going to take me a while to copy 20 some odd charges. We'll start charging the case at 1:30, and once the charge is being completed, I will grant deference to at least one juror. It says, Judge Coffey, can we please start on Monday morning? And we'll argue the case at 10 o'clock on Monday morning. Anything else we need to do before we take this recess? We call the court into recess. The court will stand in recess until 1:30 p.m. and we'll start the jury charge at 1:30.
All right.